Right. Zenat, stay with us. We have reactions coming in from lawyers right after the Karnataka High Court's verdict. Let's have a listen.
Yes. Test number one was whether the practice preceded the religion itself. Number two, without practicing the same, whether religion will cease to exist. Number three, whether it is obligatory or optional. And two other tests have been laid by the Supreme Court. By applying those tests, it was clear that this does not form part of essential religious practice.
Sir, the petitioners clearly said that even before the judgment that they will go back to the Supreme Court and they'll fight it again.
See, under our scheme of the Constitution, any order passed by the High Court, you can avail the remedy of filing a special leave petition on appeal before the Supreme Court. It is perfectly open for any of the parties to move the Supreme Court.
But you're satisfied?
But I am very sure that the judgment which has been delivered by the High Court is based on sound legal principles and based on factual foundation.
Sir, it's been 11 days continuous hearing was done. Before that, do you think the bench has been considered each and every point of it?
Most certainly. You could see the judgment itself. It is a very well considered judgment running more than 200 pages. So obviously the court has taken all the, or it considered all the submissions made by the respective counsel.
College ಆಡಳಿತ ಮಂಡಳಿಗಳು ಸ್ವತಂತ್ರವಾಗಿ
ನೋಡು ಬರ್ತಿದ್ಯಾ ನೋಡು ಬೇಗ ನೋಡು.
Right, let me quickly cut across to KV Dhananjay, who is a Supreme Court advocate practicing in Bengaluru. Mr. Dhananjay, this is the High Court's verdict in Karnataka that says hijab is not an essential practice in Islam and that the Karnataka government's view and definition of uniformity must be maintained. It's almost upheld their definition, the government's definition on uniformity, and almost given the CDC itself as a body enough validity to frame its guidelines. How do you look at this verdict?
Well, with the great respects to the court, I don't think the judgment is quite acceptable from a constitutional perspective at all. Again, with great respects, the court has done an extraordinary task of infusing public confidence. Now, notwithstanding that some people might agree with the decision, that some people might disagree with the decision, I think universally everybody will agree with one thing, which is that the court has infused greater public faith in the judiciary by making its proceeding available for the public to see. Something like 40 lakh persons have watched the proceedings that went on for about 8 to 10 days. Now, if the court were to physically limit people who could come into the court and watch, I think not more than 2,000 persons would have been able to view the proceeding. But now it's like 40 lakh plus. And that tells you the enormity of this matter.
That was that kind of curiosity and people really keenly watching that verdict. What did that really mean? Because this is now going to be almost like a benchmark verdict for any situation that may arise in any other state in the country. And for all you know, you could have educational institutions across India now quoting the Karnataka High Court's verdict to implement uniformity that would ban hijab there as well. Now, with hijab being called a non-essential religious practice in Islam, then you have all the authority for educational institutions to completely ban it.
Well, it's true, but I think a big part of the blame will have to go to the counsel for the petitioners because, you see, it was unnecessary to request the court to give a declaration that hijab is or is not an essential practice of Islam because, you know, for girls to wear hijab as part of their uniform, because what does the uniform say? The uniform says that you got to wear a salwar kameez. The uniform does not say anything about what should be your head covering. And in fact, that only came later. After the controversy erupted, the uniform clause was amended to say that you can't have hijab specifically. But then when the controversy arose, the uniform clause was you will have to wear a salwar kameez. And if a girl honestly believes that she's entitled to put on a religious attire over and above the uniform, who does it hurt? You know, I believe you started your discussion by asking, who does it hurt? I was looking at this proceeding as essentially one of kindness. But unfortunately, much of the blame will have to go to the petitioners' counsels themselves because why do they have to request the court to give a ruling on whether this is an essential practice?
When you say blame must go to the petitioners' counsel, do you feel the verdict here is flawed? Is that what you're trying to say, KV Dhananjay? Because what the court has upheld here is that you can't say no to uniform. You got to follow institution's guidelines when it comes to uniformity. It's at the institution's discretion. If you want to study in that school or college, you got to maintain uniformity as per the definition of that college and that institution. What's wrong with that?
Well. I don't think the judges have said anywhere in the 200-page judgment that the uniform clause here is so strictly enforced that certain Hindu groups can't even put on marks on their forehead. Is that what the judgment says? I don't think the judgment would have gone to that extent. And I don't think the Karnataka government's CDC committee is going to tomorrow proclaim that Hindu groups can't even put a mark on their forehead because, well, you see, if they have a problem with hijab interfering with the uniform, why would they not have a problem with the Hindu mark uniform interfering with that uniform? So, you have to be comprehensive. It's not enough to say that the CDC says they don't want hijab, so let's just approve it. It's not so. The CDC, if at all they have a problem with hijab as interfering with the uniform, they were expected to also recognize that, a lot of Hindu groups put on various tilaks and, marks on their forehead. How is that more acceptable, or how is that acceptable at all? You see, the judgment, I don't think, gets into that aspect. And I honestly believe the petitioners' counsels too didn't really, say much on that. I think this
Mr. Dhananjay, what the petitioners have said in court and what they've insisted while they petitioned court was that hijab is an essential religious practice in Islam. That was more or less the line of the debate. No, what I'm trying to say is the petitioners insisted... Petitioners have insisted that it is a essential religious practice, and exactly that statement is now being disproved by the Karnataka High Court. They've not gone into other debates.
Exactly.
It's just whether or not it's an essential religious practice. Yes or no, court says it isn't after 2 weeks of deliberation. Now, stay with us. I'd like to ask you on the kind of legal provisions that these petitioners have now in the days to come. Before that, I'm going to cut across to the latest developments coming in right here on India Today. We hear that petitioners in Karnataka now, those who pushed for hijab inside classrooms, are all set to move the Supreme Court. This is the next move. We hear statement coming in by the advocate Shahul for the petitioners. He says that we are consulting on the issue. Once the detailed order comes out, we will analyze it and then move an SLP before the Supreme Court. Now, this was expected. No surprises. Petitioners now wanting to move the Supreme Court on the same matter. So far, their argument in court, the petitioners and the council have been constantly that hijab is an essential practice in Islam, which has now been disproved by the Karnataka High Court. High Court, after hearing and deliberating 2 weeks after hearing much of the arguments of the petitioners' council, have said hijab is not an essential practice in Islam. Now, petitioners wanting to move the Supreme Court, will they have sanctity in their argument still? That remains to be seen. What the Supreme Court will deliberate once the matter reaches Supreme Court. But KV Dhananjay joining us. Mr. Dhananjay, these are legal provisions that the petitioners are now going to be exhausting. They're going to be headed to the Supreme Court. What do you think is expected? How do you look at this move next?
Well, it was expected because I think the matter, very senior lawyers from the Supreme Court came down to argue this matter. So if the High Court's verdict would be against the petitioners, it was all too expected that the matter would go up to the Supreme Court. For your information, tens of thousands of cases are lodged in the Supreme Court every year, and the Supreme Court, on an average, gives out 900 detailed judgments each year. So it was impossible for anybody to think that this matter would not go up to the Supreme Court on appeal. It is going to go up to the Supreme Court on appeal. And I've been watching the stand of the Karnataka government since morning. And they've been saying that whatever be the judgment, everybody will have to just not protest and things like that. Yes, I think that's actually a sound caution. But I also want to remind our Karnataka government that, if we go back to 1975, when Srimati Indira Gandhi came out with a draconian emergency, 9 high courts had struck down that emergency on the ground that you can't arbitrarily arrest citizens of India. And, though you have suspended the constitution. And the Supreme Court reversed all of those 9 decisions and held what Srimati Indira Gandhi had done, of course, without any basis, to impose emergency was lawful and valid. But then what happened after the Supreme Court said it was lawful and valid? People didn't say, oh, great, the Supreme Court has now finally given its verdict. Let's just abide by Srimati Indira Gandhi's emergency. Let's just go and get ourselves arrested. That didn't happen. The country erupted in protest. And then what happened? 2 years. Srimati Indira Gandhi had to reverse the emergency. So it's one thing for people to say that, okay, courts are final. It's another thing for people to recognize that sometimes courts can err in a very big way, so much so that in hindsight, we would see that, oh, wait, the court made a huge mistake, because the court, of course, certainly has acted honestly.
But right now, with the Karnataka High Court pronouncing this verdict, it almost now has become holy grail for the Karnataka government. And from what we see will be the next move is many of those institutions that earlier allowed hijab will now issue a blanket ban. So if we are not talking about these 6 students, petitioners, who you see on your screens here, who've been fighting for hijab inside that one college of Udupi. This will be more or less a norm and a scene situation that will unfold in several other colleges and institutions in Karnataka. As we saw right after that interim order, we saw a lot of commotion, many of them are being asked to remove the hijab right at the gates of their institutions, etc. And now it will almost be a decision viewed as holy grail by the Karnataka government. In fact, they are already appealed to institutions to follow the Karnataka High Court's verdict. It's already an appeal that the Karnataka government has made, and we will see now extensively all those institutions that earlier allowed will now disallow. They've got to maintain uniformity.
Yes.
If they've been told to, they will be doing it. Students will have to comply. If that does not happen, we're going to be seeing extensive protests maybe. If anything, Karnataka government might just detain those protesters. It will just lead to large-scale commotion, which we are hoping that does not happen. What do you think in this eventuality should be the actual response of those institutions there?
Well, 75% of educational institutions, imparting school education in Karnataka, pre-university education in Karnataka, 75% of those institutions are government-controlled or government-aided or government-funded. Now, 25% of them are private unaided institutions. Now, private unaided institutions are not going to be bothered with what the government says. And again, I've been saying this one other thing repeatedly, which is, look at, there's a small group of people who never really bother about uniforms. You know who they are? The richest schools in Bangalore, where the fee for standard 1 is 5 lakh plus. They don't have any concept of uniform there. You're free to wear whatever you want. And look at what's happening. You have the World Economic Forum in Davos, wherein every time, the Oxfam goes out to complain and say that 5% of the population, only 10% of the population holds more wealth than the 90%. And that 10% or 5% doesn't bother with uniform. And 90% is like fervent. Like everybody wants to, has an opinion about uniform. I think we also have to recognize that this concept of an uniform was something that came out 250 years ago, 300 years ago. We had this notion and ideal that we should not expose children to inequalities in life. But look at where we are. 5% or maybe 1% of the population has more wealth than the balance 90%. Or something like that. So I think it's time to really throw out this uniform concept and then not brainwash our children into thinking that the world is fair, we have economic equality, because we don't have economic equality, because
like you rightly said, Mr. Dhananjay, we are such a religiously diverse country. If there isn't uniformity maintained inside classrooms, then we could only see this situation escalate, in ways that we saw in Shimoga, where saffron-clad boys came up saying... we already saw examples of it. We saw boys wearing the saffron shawl saying that now they must be allowed inside classrooms wearing the saffron shawl. So to avoid that, maybe this verdict will only help ease the situation. But stay with us, Mr. Dhananjay. I know you have something to say, but we have some reactions coming in. Mehbooba Mufti now tweeting on this, saying, and I quote, Karnataka High Court's decision to uphold the hijab ban is deeply disappointing. On one hand, we talk about empowering women, yet we are denying them the right to a simple choice. It isn't just about religion, but the freedom of choice. This is Mehbooba Mufti's tweet, as she's been constantly rallying behind those girls, wanting for hijab to be allowed inside classrooms. Here is Mufti saying Karnataka High Court's decision is all set. In fact, decision to uphold the hijab ban is deeply disappointing. Akshita Nandagopal joins us right from the newsroom here. Akshita, Mehbooba Mufti now jumping in, saying that this is deeply disappointing. The High Court's decision and verdict that says hijab is not an essential Islamic practice and therefore uniformity must be maintained, almost upholding Karnataka government's definition of uniformity inside classrooms.
Not surprising, really, Nabila, because from the start, you've been tracking the story closely. A number of reactions have come in. One of the active voices was that of Mehbooba Mufti. She said that this isn't about...
Akshita, apologies. I'm going to quickly cut across to Nagarjun there joining us. He's speaking to a lawyer on the same. Let's cut across.
The court has held fundamentally that it's not an essential religious practice at all. So the question of public order.
Students are likely to move the Supreme Court. Now, how is the government prepared? Are you also preparing to contest that in the Supreme Court if it's appealed?
Most certainly. We have raised substantial contentions before the High Court. If and when the matter is moved before the Supreme Court, we shall answer this.
Any likely to move a caveat or anything in Supreme
We will have to decide in consultation with the government what is to be done. Thank you.
But you're happy with the verdict today, sir, because it was the longest of the longest hearings that...
Only because apart whether it is for the state or against the state, it settles an important question of law raised and also the unseemingly avoidable controversy. I'll say that. Thank you.
Sir,
All right, there you have it. The lawyer there saying that he hails the Karnataka High Court's verdict. It really settles all that confusion and discussion. Let me quickly cut across to Akshita there, giving us details on what the kind of political reactions coming in. Akshita, you were saying Mehbooba Mufti now slamming the Karnataka High Court's verdict, calling this absolutely disappointing. She's been constantly rallying behind those girls wanting for hijab inside classrooms. How do you see the situation unfold politically?
The reactions that are coming in from the likes of Mehbooba Mufti, from the Congress, is no doubt going to be following the same script here, Nabila. The BJP, of course, is coming out to say that this is exactly what we were talking about, that we must follow uniformity. The focus must be on education, as you also heard from the Karnataka Chief Minister a few moments ago. We've also accessed the transcript of the oral order that was dictated in the Karnataka High Court. So we're going to be putting that out for you briefly as well.
Akshita, apologies. I'm going to quickly cut across to Pramod, who's joining us from Shimoga. He's speaking to Ishwarappa, the man who's been constantly speaking on the hijab issue. Let's cut across Ishwarappa in Shimoga. Back, Ishwarappa there has been hectically commenting on the hijab row, saying that guidelines must be followed.
कोर्ट ने बोला कि this is not an essential religious practice.
ये हिजाब के बारे में कोर्ट क्या डिसीजन लिया है, मैं बहुत संतोष से उसको स्वागत कर रहा हूँ, क्योंकि बहुत दिन कर्नाटक के मुसलमान वो विद्यार्थिनियों को बहुत प्रॉब्लम हुआ था. कोई आदमी उनको प्रचोदन दिया था, इसलिए ये प्रॉब्लम था. लेकिन आज कोर्ट क्या डिसीजन लिया है, उसको कौन कौन प्रचोदन दिया था, वो पहले उनका क्या करना है वो डिसीजन लेना है.
कोई आदमी माने कौन है सर? हाँ, कोई आदमी माने कौन है वो
मुझे मालूम नहीं. इसलिए सभी विद्यार्थिनियों को अच्छा शिक्षण देना है, इसलिए कोर्ट क्या बोला है वो सभी भी उसका मानना है.
सर अभी भी मुस्लिम लोग ना
कोर्ट को मूव करने वाले हैं,
वो
उनके एडवोकेट्स ने बोला
ये प्रजाप्रभुत्व में क्या करना है क्या नहीं करना है, किसको क्या क्या स्वातंत्र है वो करने के मौका है, करने दो.
सर अभी लॉ एंड ऑर्डर सिचुएशन शिवमोगा में कैसा है सर?
सिर्फ शिवमोगा में नहीं, सारे कर्नाटक में लॉ एंड ऑर्डर सिचुएशन बहुत अच्छा है.
एक और बात है कि मुस्लिम पेरेंट्स बोल रहे हैं कि हिजाब लेंगे तो बहुत बड़ा सा तकलीफ हो जाएगा.
Well, there you have it. Ishwarappa, Karnataka minister there, hailing the High Court's verdict. He says that uniformity must be allowed. They've always maintained that in schools, in colleges, there must be no differentiation. Students must follow the uniform mandated by the college or school institutions, and there must be no debate on that, with the Karnataka High Court now pronouncing its verdict, saying that hijab or any other religious symbol will not be allowed. Students must respect uniformity prescribed by those institutions, and almost declaring that hijab is not an essential practice in Islam now. Comes as a huge setback for those girls who've been pushing for hijab inside classrooms, calling it their religious right under the constitution. Many of these petitioners now going to be stepping up their ante, will be now approaching the Supreme Court. That's the information that we have now, that these girls who have been the petitioners right from the start, pushing for hijab inside classrooms too, have now decided that they will approach the Supreme Court. They will be, of course, exploring different legal options to try and, of course, push their debate on hijab being an essential practice. Remember, these girls have been constantly saying that hijab is an essential practice, while the court has said it isn't. It is not an essential practice. After 2 weeks of hearing in court, now finally the verdict is out. Pramod is in Shimoga. Shimoga is that one district where we saw large-scale violence that unfolded, unfortunate situations and scenes where students were pitted against the other, one community against the other. We saw that happening in college level, in school level, educational institutions where we saw large-scale polarization, very upsetting sights that unfolded in the weeks that went on with the hijab controversy raging. Today we see a very eerie silence in that district of Shimoga. Take us through exactly what the Minister Ishwarappa said. He was in fact thick into this controversy. The Congress accused Ishwarappa of fanning violence and fanning protests by the Hindu right-wing groups. What did Ishwarappa say today to you?
It absolutely is, Nabila. He, in fact, once became a center point of the controversy at this point. In fact, he's holding a meeting regarding the Prime Minister's visit now. And just like you mentioned, he did comment claiming that he's welcoming the order and students should follow the dress code, the uniform code. And that's what he has said over there. In fact, just like how the court gave brought in three holistic questions and gave answers to that, like Ishwarappa was also given separate answers to very important aspects here. First, welcoming the order. Second, saying that students should abide by the order. And just like CM Bommai said that education is a very important, essential factor, he has also gone ahead and said the same thing. Then he says that in Shimoga, we did ask him about the violence that occurred earlier. He said nothing like this is going to happen again. Everything is normal over here, not just in Shimoga, but in entire Karnataka. Law and order situation is under control. This is what Ishwarappa, Minister, has said. And then he also said that if the petitioners want to approach the Supreme Court, it is their right and they can go ahead and do so.
Well, undoubtedly, this is, of course, their right to explore different legal avenues, and we see that the petitioners are already gearing up to do that. The Petitioners' Council also spoke that they are trying to deliberate on what kind of legal options that they can explore, and the next step is naturally for them to head to the Supreme Court. The Supreme Court had earlier very clearly said, we're going to wait for the High Court's verdict, and only then will they intervene if need be. Already petitions have been shot to the Supreme Court, but it appears that they waited for the Karnataka High Court's verdict, and now that the verdict is out, Akshita, Supreme Court hopefully will take up the matter and maybe deliberate further on whether or not hijab is an essential religious practice. But for now, the Karnataka High Court's verdict has almost become holy grail for the Karnataka government. They've already declared and spoken to the media. We carried it right here on India Today with Basaraj Bommai, appealing to all institutions, saying, please respect the High Court's order. Let's maintain uniformity, and education is, of course, of priority.
That's right. Nabila, let me just break down for you what was mentioned in the Karnataka High Court. We've accessed the oral order. This is not the detailed verdict, but this is the oral order that was pronounced and dictated by the three-judge bench. There were 4 questions that were put up, and let's just break that down for us, for the viewers. The first question that was put up was whether hijab is a part of an essential religious practice. The answer to that from the High Court bench is, our answer to the question is, we are of the considered opinion that the wearing of hijab by Muslim women does not form a part of religious essential practice in Islamic faith. So this was the first setback that in fact the petitioners faced. The fact that they said that this does not form a part of the essential religious practice of Islamic faith, which was the basis of the argument of the petitioners. Number 2, the answer to the question of whether in fact the prescription of a uniform is a violation of students' constitutional right. It says that the prescription of a school uniform is only a reasonable restriction constitutionally permissible, which students cannot object to. So 2 important points mentioned here. This is a second setback for the petitioners, again, with in fact the High Court saying that this particular argument also doesn't hold. Another question was about the government order, which said that uniformity must be maintained, hijabs, religious symbols not allowed. To that question, the High Court has said, we are of the considered opinion that the government has the power to issue the impugned government order dated 5th February, and no case is made for its invalidation. Setback 3 right here for the petitioners. And finally, the last issue that was raised is in fact with the Karnataka High Court saying we're of the considered opinion that no case is made out. This is the petition number for issuance of a direction for intimating disciplinary inquiry. The prayer for issuance of a writ is rejected, being non-maintainable. Now, accordingly, in the above circumstances, all these petitions being devoid of merits are liable and accordingly dismissed. All pending applications fail into insignificance and disposed of. This is the oral order that was mentioned in the Karnataka High Court. Let me again highlight 3 big setbacks for the petitioners. 1, that hijab is not a part of an essential religious practice. 2, that students cannot object to schools and colleges having a uniform and prescribing a uniform. 3, that the government has the power to go ahead and issue an order. It's not unconstitutional. They very much have the power to do this. And it's because of these 3 aspects mainly that the petition was shot down and dismissed, Nabila.
Akshita, thank you very much for breaking that down. There you have it very, very clearly that the Karnataka High Court, as it pronounced its verdict, first says it's not an essential religious practice. Second, students cannot oppose to uniformity. And the third, that the order that Karnataka government gave on uniformity is not unconstitutional. Let me quickly cut across to Prahlad Joshi, Union Minister who also hails from Karnataka, has a word to say on this High Court verdict.
बातचीत करने के लिए संसदीय मंत्री प्रहलाद जोशी। प्रहलाद जी, आज हिजाब को लेकर कर्नाटक हाई कोर्ट ने साफ-साफ कह दिया है कि हिजाब जो है किसी भी धार्मिक उसका जो है प्रतीक नहीं है, इसलिए जो भी यूनिफॉर्म स्कूल कॉलेज डिसाइड करते हैं, इंस्टीट्यूट डिसाइड करते हैं, वही पहन के आना चाहिए।
जो कुछ भी निर्णय जजमेंट आज हाईकोर्ट ने दिया है उसको सबको पालन करना है। तो अभी जो कुछ भी हुआ है मैं इतना ही निवेदन करता हूं, छात्र का एक ही उद्देश्य रहना चाहिए, पर्पज रहना चाहिए, एम रहना चाहिए कि ज्ञानार्जन करना। अभी आप ज्ञान के लिए जा रहे हैं, ये सब बंद करिए, किसी में इसमें ज्यादा पॉलिटिकल स्टेटमेंट मत कराइए, कृपया जाके कॉलेज या स्कूल में पढ़िए और ये सब जो कुछ भी हुआ है वो भूल के सब भाईचारा दिखाते हुए काम अपने कॉलेज में अपने स्कूल में पढ़ाई करिए, इतने मैं निवेदन करता हूँ। इसमें फिर से क्योंकि अभी न्यायालय ने निर्णय दे दिया है, सबको मानना पड़ेगा, तो हमारा इसमें तो कोई और कोई ऑप्शन भी नहीं है। इट इज ए मैंडेटरी दैट एवरीबडी शुड फॉलो इट। इतना ही मैं निवेदन करता हूं, इसमें ज्यादा पॉलिटिक्स न करते हुए सब इसका स्वागत करें और इसके पालन करें।
सर, इसमें लेकर जो कंट्रोवर्सी जब हुई थी तो कर्नाटक से चलती चलती उत्तर प्रदेश, महाराष्ट्र तक पहुंच गई थी। कुछ लोगों ने कहा था कि ये धर्म के ऊपर जो है वो कुठाराघात है।
नहीं, इसमें मैं इस समय मैं ज्यादा टिप्पणी नहीं करना चाहता हूं। अभी हाईकोर्ट का निर्णय हुआ है, हाईकोर्ट का निर्णय सभी पालन करें, यही मैं
नीति नहीं होनी चाहिए,
नहीं होना चाहिए, पक्का नहीं होना।
ये थे प्रहलाद जोशी, कैमरामैन संजीव कुमार के साथ हिमांशु मिश्रा, दिल्ली, आज तक।
All right, there you have Prahlad Joshi, who also hails from Karnataka, requesting for peace and harmony and for people to accept the Karnataka High Court's verdict and continue with their education. Now, we know education is of top priority. The petitioners who've been debating and arguing through their counsels in court have asked time and again, how does hijab interfere in education? Or the fact that the court now almost saying that students cannot reject uniformity. Students in their petition have, in fact, raised questions like, how does hijab really interfere with uniformity? These are questions that they were asking time and again while they were protesting and even through their counsels. Here, the Karnataka High Court now very clearly stating that there can't be an argument when it comes to uniformity. If the college or school prescribes certain style of uniform, that must be maintained. And uniformity is sacrosanct. This is important. Students must follow it and they cannot reject uniformity in classrooms. This is what the court has said, while very clearly stating and declaring that hijab is not an essential religious practice in Islam. Remember, you had extensive arguments that came in from the counsel of the petitioners who argued that hijab is an essential religious practice. It has been mentioned in the Quran multiple times. It has been followed for centuries in India and other parts of the world as well. And this is very sacred and sacrosanct for girls in the Muslim community. This was the argument by the petitioners' counsel, who said that hijab must be allowed even in classrooms, even in education institutions. But now the court very clearly declaring, after arguments that they've heard from both ends, that the court now, while it pronounces its verdict, says hijab is not an essential religious practice and that students cannot protest a prescribed uniform that has been issued in their college institutions, and also very clearly stating that the Karnataka government's fresh order that claimed uniformity must be maintained, no religious symbols must be allowed inside, is not unconstitutional and that it has absolute validity. Now we're looking at a big decision now that's come by the Karnataka High Court, a verdict that was pronounced, which it appears educational institutions across Karnataka will have to follow. Remember, this comes as almost a benchmark verdict. What the Karnataka High Court has pronounced will be benchmark to all those courts in the future, including the Supreme Court, while if at all it deliberates on the matter, as petitioners now seek Supreme Court intervention. This is what we hear. But this is almost a landmark verdict for several other states, if in case a situation like this arises, not just with the hijab or in fact any other kind of religious symbol, if at all students push to wear inside their classrooms, this will be almost a referral verdict. Verdict that will, of course, resonate across India if a situation unfolds in different parts of the country. In Karnataka itself, it has come as a massive debate on whether or not this right to profess their choice of religion is allowed inside classroom, or is that right which comes under the Constitution is left only out.